I'm Damin Murdock, principal lawyer at Leo Lawyers. Although this looks and sounds like me, what you're watching is my AI avatar presenting from a script I've approved. If you're a builder with a terminated contract, you might think you can simply claim unpaid work through quantum Meruit, but after the High Court in Mann versus Paterson, and now A.M.O. Rifat Holdings versus DIB, that assumption is much more difficult. This decision gives us important guidance on what builders need to prove and how courts distinguish cost from value. Today, I'll walk you through the case, explain the reasoning, and discuss what it means for the construction industry. Historically, builders could often rely on quantum Meruit to claim the reasonable value of work after a contract ended. In some cases, that reasonable value could actually exceed the amount originally agreed upon in the contract. However, the High Court significantly restricted that approach in the landmark Mann versus Paterson decision. The principle was that agreed pricing should ordinarily govern the relationship between the parties. Courts should generally respect the contractual structure rather than allowing one party to bypass it upon termination. But Mann versus Paterson left practical questions unresolved. Specifically, what evidence does a builder actually need? That's where A.M.O. Rifat Holdings becomes particularly important. It involved a $1.6 million contract for a 3-story home. Parties also entered a side agreement for an additional $110,000 in cash installments outside the main contract. They adopted Method B under the Domestic Building Contracts Act, allocating 10% of the price to each of 10 stages. As construction progressed, the builder claimed stages were complete, but the owners alleged defects and withheld payment. The builder stopped work and terminated for non-payment, while the owners counterclaimed for defective work. Parties were now arguing about payment milestones, whether money was due, and the validity of the termination. Following termination, the builder brought a quantum Meruit claim for approximately $365,000 for work performed. The builder argued that even if the contract mechanism failed, the owners had received the benefit of substantial work. The owners challenged the claim and the side agreement, arguing it was inconsistent with the Domestic Building Contracts Act. Quantum Meruit is a restitutionary remedy designed to prevent one party from unfairly retaining a benefit without paying. The critical issue is proving the value of the benefit received. The builder relied heavily on internal invoices and records, but the court held that expenditure alone isn't enough. Invoices show costs, not necessarily the value to the owner. Expenditure can include inefficiencies, rectification, or management costs that don't increase the objective value of the work. Because the builder failed to prove the objective value of the benefit conferred, the quantum Meruit claim was dismissed. Builders must now support their claims with quantity surveying or expert valuation evidence of the work's objective value. The real question isn't what did this cost the builder, but what benefit did the owner actually receive? The court also found the separate cash agreement void, as it contravened Section 40 of the Domestic Building Contracts Act. You cannot contract around statutory protections just because both sides agree. If it's inconsistent with the law, it's unenforceable. Consequently, the builder was not entitled to keep the $50,000 already received under that unlawful side agreement. This reflects a shift in construction litigation. Quantum Meruit is no longer a fallback to simply reimburse spent money. Builders need to document everything early. Progress photos, variations, and completion percentages are essential. There are 3 major lessons: prove the value of the benefit, use expert evidence, and be wary of side agreements. While this involves Victorian law, the principles are likely to be influential elsewhere, including New South Wales. In NSW, cases like Field versus Detman create interesting comparisons regarding payments for uninsured building work. A.M.O. Rifat is a reminder that construction litigation is evidence-driven. You must prove the value of what was delivered. If you need advice on a building dispute, visit us at leolawyers.com.au. Thank you for watching.